Hello, and a warm welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm EDRM CEO and Chief Legal Technologist. Today's webinar is a collaboration with our trusted partner, eDiscovery Today, titled Important eDiscovery Case Law Decisions for February 2026. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck, and myself. We are recording today's session for future on-demand access, and slides will be available after the webinar. And this webinar, along with all EDRM webinars, will be available on the EDRM Global Webinar channel for the next quarter to help support your ongoing learning and reference needs. Questions will be answered both during and at the end of this webinar. Holly Robinson, EDRM Senior Marketing Operations Manager, is here with us. Holly, can you please share what resources are available today?
Thanks, Mary, and we are loving On24 with so many ways for you to engage. If you look at the bottom of the screen, you'll see the console. The question mark icon is where you can type your questions for today's faculty, and we highly encourage you to do so. You'll also see the paperclip icon. If you click on it, you'll find today's resources. You can download the On24 engagement tool descriptions to help you better engage with the platform. There's a link to subscribe to the eDiscovery Today blog, an excellent way to stay informed every day. You'll also find a link to learn more about the Honorable Judge Peck and how you can engage with him. Right below that, there's a link to get your copy of Tom O'Connor and NextPoint's book, Artificial Intelligence for the Rest of Us. You'll also see a registration link for next month's case law webinar on March 17th, and we'd love to have you join us again. And be sure to register for Haystack ID's upcoming webcast next Wednesday, Real Benefits, Real Constraints, a practical guide to Copilot rollout. If you'd like to learn more about today's faculty, click on the speaker bios and they'll pop open with more details about our presenters. And just like on Zoom, you'll see the smiley face emoji and lots of other reactions. Please feel free to use them throughout the webinar. Finally, click the LinkedIn logo to follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Holly. And today's faculty, of course, we have Doug Austin, the editor of eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, best practices, and case law. Doug is an established eDiscovery thought leader with over 30 years of experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has written numerous articles and white papers, receiving JD Super Reader's Choice Awards as the top eDiscovery author and top cybersecurity author. Doug has presented at numerous webcast events and all of the best conferences. And Tom O'Connor, affectionately known as Tom O, is the director of the Gulf Coast Legal Technology Center and a nationally known consultant, speaker, and writer in the area of computerized litigation support system. Tom's consulting experience is primarily in complex litigation matters where he's worked with firms of all sizes, and he's also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. And Tom hosts, along with Rocky Messing, the eDiscovery channel on YouTube, and is the author of Artificial Intelligence for the Rest of Us and eDiscovery for the Rest of Us, the Checklist Manifesto, as Holly alluded to earlier. And we also have with us the Honorable Judge Andrew Peck, who is a Band 1 Chambers-ranked senior counsel at DLA Piper after having served 23 years as a United States Magistrate Judge for the Southern District of New York. And before his appointment to the bench, Judge Peck was in private practice, focusing on commercial and entertainment litigation, including copyright and trademark matters, with extensive trial experience. And at DLA, Judge Peck advises on IP and also serves as a resource for the firm and its clients on litigation strategy and discovery issues, information governance, and cross-border discovery from a judge's perspective. Also sought out as a conference speaker concerning eDiscovery issues, Judge Peck has been retained to serve as special discovery counsel to clients and law firms and to submit expert reports on eDiscovery issues. And EDRM is grateful to all three gentlemen for their service on the EDRM Global Advisory Council. And without further ado, on President's Day of all days, Doug Austin, do we have some cases?
It is President's Day. Don't get some people started, but some of you are here, so we're glad you're here. And yes, Mary, we do have 6 unique cases to discuss this month, and I'll show you the topics instead of talking about them. We'll get into them here in a moment. Of course, we do welcome questions, and we'll try to get to as many as we can. And we'll send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. If you take a picture of this disclaimer, it's still valid, even in camera.
Ooh. Ooh.
Here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Minerva 26, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. Minerva 26 has over 45,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. Minerva 26 is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. In this first case, Geico filed a motion to compel plaintiff to produce documents responsive to request for production number 2, which sought all documents that SRH's expert witnesses reviewed in forming his or her opinions in this case. SRH served its expert disclosures, including the expert report of Christopher Lee. He attached some exhibits to his report, including spreadsheets, exhibits C and D. When Geico requested that SRH provide exhibits C and D in native format, plaintiff provided them. Geico maintained that such spreadsheets were missing the document/data input into exhibits C and D, and plaintiff's counsel responded, the data set forth in exhibits C and D was compiled into spreadsheets on an ongoing basis during the conduct of SRH's business. Payments of commissions were recorded as they were received by SRH. The commission statements from which the information was taken are not presently available. Therefore, additional documentation of the data cannot be produced. Plaintiff also stated that it produced a spreadsheet, which Richard Hurwitz, SRH's principal, created in its native form, setting forth monthly non-automobile insurance commission income for the entire period of its business operations, which was attached as Exhibit C to Lee's report. In addition, Lee also provided his own spreadsheet, which he created on the basis of information received from plaintiff, which contains the same data upon which damage calculations were made. In considering Geico's motion, Massachusetts Magistrate Judge Jennifer Bowles stated, Geico complains that SRH has not produced the underlying source data, inputs, or intermediate computational materials used to generate these spreadsheets. Such documents, however, are not responsive to RFP number 2. While such documents may be relevant to this action, Geico has not cited any other request for production that would encompass such documents. Continuing, she said, it is undisputed that Lee never received nor reviewed the underlying materials that Geico seeks. Rather, Lee received the spreadsheet that Hurwitz created and used that spreadsheet to make his own calculations. As such, those materials are not discoverable under Rule 26A2B2. Denying Geico's motion to compel, Judge Bowles stated, this court therefore has no authority to order SRH to produce the materials that Geico seeks. At the January 14 hearing, however, SRH's counsel expressed a willingness to provide voluntarily available bank statements showing commission payments and any commission statements still in the possession of SRH. This court encourages SRH to do so. She also denied Geico's request to redepose Hurwitz and its request for sanctions. So, Tom, while we don't know all the RFPs that were submitted by Geico, submitting an RFP that seeks all commission statements seems so easy even a caveman could do it. Assuming, yeah, I had to throw that in there. Assuming they did include an RFP for that, should that have been what their motion to compel was based on instead of documents reviewed by the expert?
See, now I got a mental image of the deposition room with all these cavemen sitting around. Oh my God. Well, yeah, that obviously that would be one thing. Look, I wonder how much of this is some inexperience with dealing with maybe this type of data and or this type of an expert. I mean, I've been involved in lots of cases where if there's a big external database, we know that the expert is not going to have that he or she is going to have a report that was generated by that. So lots of time when we're doing the request for the expert, we specifically say the material they reviewed and or any underlying source data that the reports may have been based on. If those are not the original, if that is not the original data that had been preserved, and it's just it's a common thing. So you could add that into that RFP. You can have a specific RFP for that source data. You could have if it is in fact a separate database, you could put in a request for inspection, which I've been on several cases where we've successfully asked for that, and the court has allowed us to bring in an expert on SQL databases, for example, and sit down with the IT people from the other side and query the database directly. So yeah, there's lots of different ways to do it. My initial reaction though is this is something that would be ripe for discussion at the meet and confer. Mm-hmm. Like before you get to discovery requests, why hadn't you ironed this out? And and all the initial disclosures and the everything leading up to the meet and confer, you're supposed to identify your experts and what they're going to talk about. Why wasn't this hashed out at the meet and confer? And what are you going to be using? What are you going to be giving us? Do we need to ask for it? And I hung on, I think it's in your last statement there. Yeah, the last paragraph where SRH's counsel expressed a willingness to provide voluntarily available bank statements. So it seemed like there was some intent there, or at least some leaning towards some cooperation, that maybe if this had been brought up at the meet and confer or brought up earlier, this sort of dispute could have been avoided. So I wonder how much was maybe not having a lot of experience dealing with experts using reports from extrinsic data.
Mm-hmm. Well, sure. I definitely think that's a question. And of course, expressing the willingness in court, doesn't necessarily mean they were willing earlier in the case.
No, I agree. I said it seemed to indicate that they did.
Yeah. Well, and I'll have a question for Mary on that here in a moment. But first, Judge Peck, it seems logical that Geico wouldn't anticipate that the only quote-unquote documents reviewed by Lee informing his opinion would apparently be Hurwitz's spreadsheet. So given that Judge Bohl also denied Geico's request to redepose Hurwitz, what can they do, if anything, to attack the assumptions on which Lee's expert report was based?
Well, in addition to everything that Tom said, one can sometimes make more headway in cross-examining an expert by going through what data the expert didn't see, didn't ask for, wasn't given, has no idea how the Hurwitz spreadsheets were prepared,
right.
All of that, which would undermine the credibility or reliability of what the expert is saying. So sometimes lack of data can be data.
That's a great point, indeed.
Great point.
And I think might address Sheila Greeley's question about about the validity of the data being used and assumed to be valid. So I'll if there's anything Judge Peck you have to add, if you're seeing her question there, she's asking would the outcome have been different if the validity of the data used for the spreadsheets.
I think that's the whole point. If the expert is just they gave me one piece of paper, it's got a lot of numbers on it, that's what I'm relying on. Well, that raises the question of, is that information reliable? Why don't you have other data, et cetera, et cetera, et cetera. So,
right. Yeah, for sure. No doubt about it. So, Mary, one thing I thought was interesting is SRH stated earlier that commission states were not available, but counsel later expressed a willingness to provide any commission statements still in the possession of SRH. So does it sound like SRH is playing games with the evidence? And Mary, are you muted?
Of course I am. Of course I am. But yes, yeah, and you did catch them, Doug. But I also got a sense that possibly the spreadsheets that they were working with were constructed on a weekly or monthly, some kind of periodic basis, based on those commission statements, and that they might not have had a complete set of them. And I'm reading, reading between the lines, but I do think Tom's point about and Judge Peck's point about what's underneath the spreadsheet and especially formulas or data pulls into the spreadsheet can really broaden the scope of discovery if you have that. So I can understand why they'd want it, but not every spreadsheet is a data pull. Some of them are hand entered.
Right. Yeah, which it sounds like a good bit of this one was, at least Hurwitz's spreadsheet, which led to the expert spreadsheet. So interesting case, and we'll move on to the next one, in which Plaintiff Felder challenged the defendant's redactions and privilege withholdings and sought either compelled production of unredacted materials or alternatively in-camera review. The dispute arose after Felder filed a letter motion challenging the defendant's production under a prior opinion and order concerning materials from WBD's internal investigation. Felder argued that the company had improperly redacted and withheld documents based on claims of attorney-client privilege and work product protection. He requested that New York Magistrate Judge Gary Stein order full production or conduct an in-camera review. WBD responded that its privilege assertions were proper, but stated it was ready and willing to defend its redactions and withholdings of documents that plaintiff identifies on the privilege log and to comply with in-camera review if Judge Stein so desires. The first of four categories of challenged redactions and withholdings involve documents redacted based on the mental impressions of non-lawyers. Citing FRCP Rule 26b3 and precedent, Judge Stein explained that the work product document is not limited to documents prepared by an attorney or documents that reflect an attorney's mental processes. He also stated that it is of no consequence that most of the subject documents were prepared by non-attorneys because the doctrine applies to materials prepared by party representatives, including agents and consultants. Judge Stein also cited authority recognizing that interview notes prepared by non-lawyers, supervised by and acting at the direction of an attorney, can qualify for protection. Applying those principles, Judge Stein reaffirmed that he had already found the investigation materials were covered by attorney-client privilege and work product doctrine, and that the non-lawyer investigators were acting at counsel's direction. The earlier phrasing that referenced mental impressions of an attorney was not meant to strip protection from similar materials prepared by non-lawyers. Judge Stein expressly clarified that such materials remain protected. The exclusion from waiver applies to protected mental impressions, even if prepared by non-lawyers, so long as the other requirements for work product protection are met. Regarding Felder's other three categories of redactions and documents withheld, Judge Stein stated, Felder has not demonstrated that WBD improperly withheld or redacted any documents. The court thus finds no basis to compel WBD at this time to produce any additional documents or to unredact any information. Instead, the court will conduct an in-camera review of a representative sampling of the redacted and or withheld documents to assess whether WBD has properly implemented the court's rulings in the O&O. So he ordered that Felder may select up to 20 documents from WBD's privileged logs for in-camera review. That's all, folks. So, Judge Peck, do you agree that in-camera review is necessary in this case? And if so, is a review of 20 documents a large enough sample to confirm that WBD is properly applying any redactions?
Whether in-camera review is necessary, I guess, is in the eyes of the beholder. We've been seeing more and more judges in the cases we cover and others we read but haven't covered, where the court is saying, no, the priv log had better be sufficient. I'm not looking at the documents. But going to the second part of the question, is 20 enough? It is typical for judges, particularly in my old court, Judge Stein's court, the Southern District in New York, to look at a limited number of examples, whether it's 20 or 50, but it's small numbers, not large, 50,000 or 5,000 like we saw in the case last month, selected by the party doing the challenging. So it's not just a full random sample, it's the ones that the party challenging the withholding of information believed to be improper. That will give the judge the ability to see if the challenges are well-based. That can also give the parties, or if necessary, the court, further evidence as to whether further document review or in-camera review is necessary. And often, I must say, you look at the challenge documents and it's like, what was the party calling it privileged thinking? There is nothing in this redaction that looks privileged at all. And you see enough of those in the sample and you wind up sending the parties back to redo it all or to say you've lost your privilege, apply this ruling to any other similarly redacted document, etc. It is very compelling.
Mm-hmm. Yeah, absolutely. Interesting. And yeah, I wondered if this was your old court. So good to know that. And 50,000, remember that number because we'll be revisiting that here in a bit. So Mary, when we say document preparation supervised by and acting at the direction of an attorney, how far does that extend? If an attorney simply provided instructions to non-attorneys on what they want, is that enough?
Well, I think probably not. It's certainly not enough when you're looking at a legal hold and instructions for a legal hold that you just do the spray and pray approach that, you send it out and you hope everybody understands it and complies, but don't really supervise or do some sampling to see, to see if people understand. And I was on a case where they changed counsel because of an adverse privilege ruling, and the incoming counsel gave us a master class in working with attorneys. We were a service provider, and we had a whole ecosystem of service providers on this. It was a very large case. Everybody who worked on the case had to be on a call where they instructed us, and then they asked us whether we understood, and we had to comply in writing. They were doing belt and suspenders kind of approach, but so I think the privilege can extend, through various organizations, but I do think it needs to be supervised and evaluated.
Mm-hmm. Yeah, I think so. So, Tom, if non-attorneys can generate work product at the direction of an attorney, can an AI model being used by an attorney generate attorney work product, especially if the setting to train the model is off?
Well, I would say yes, but not especially. I would say necessarily. I mean, the privilege. I think the work product and privilege, but you got to make sure you're not violating the confidentiality requirement. And first of all, by ensuring that the training is turned off, are you using, or is the product using some sort of a RAG, a retrieval augmented generation system that's, just using or pointing to your specific documents and putting a fence around that? So I think, sure. I mean, obviously, as the judge says, if, mental impressions prepared by non-lawyers are protected. Certainly something done by a lawyer using a tool is, but the lawyer has to make sure that confidentiality is protected. And I think we'll see it maybe one or two of the later cases. Some of these products, some of these AI companies specifically say they're not guaranteeing that. So it depends on how you've set it up and what guardrails you've got in place. Yeah.
Right. Yeah. And, one of our audience members asked the question, wouldn't the privacy be affected if using AI? And so that's why I was asking the question, considering we were just, you provided a case to me last week about the client using AI to generate documents that he turned over to attorneys, wasn't attorney directed. but he was using Claude, and Claude has the opt-in approach to training the model as opposed to the opt-out. So that's why I was kind of asking the question there. If you're, is it considered private if you're not training the model, and would that impact things?
I think that's got to be really the first thing you want to look at if you're using client documents is, are you protecting the confidentiality?
Right. Yeah. And my rule of thumb would still be never put client documents in a public AI solution.
Yeah.
So,
yeah, exactly.
For sure. Okay. So let's move on to our next case, which was also covered by our friend Michael Berman. This dispute arose from CareFirst's effort to use Johnson & Johnson's privilege log entries, email subject lines, and document metadata to establish that J&J knew about certain Momenta manufacturing patents at the time of acquisition and intended to use them anti-competitively. While CareFirst framed this evidence as merely establishing timeline and knowledge, Virginia District Judge Jamar Walker concluded that the probative force of CareFirst's argument depended on impermissible inferences about the substance of privileged communications. Judge Walker began by recognizing that privileged logs are not categorically inadmissible. Citing Fourth Circuit authority, he acknowledged that privileged logs can be admissible evidence, particularly where they are used to establish the fact or timing of a communication. But he also made it clear that admissibility ends where a party's theory of relevance requires a jury to infer what privileged communications must have discussed. As he explained, a negative inference should not be drawn from the proper invocation of the attorney-client privilege. Allowing litigants to suggest what privileged communications must have been about, Judge Walker reasoned, would directly contravene the purpose of the privilege, which is to encourage full and frank communication between attorneys and their clients. He also barred CareFirst from presenting privileged log entries or metadata disconnected from their families, warning that doing so would be likely to substantially mislead the jury. Ultimately, Judge Walker granted J&J's motions in limine in part, stating the court finds the following uses of J&J's privilege log may be admissible, subject to CareFirst laying down a proper foundation as to the meaning of the metadata fields. First, use of the created sent date metadata field for the purpose of showing the fact of a document's creation or download if presented in conjunction with the family ID field to provide the context of whether the document was part of a family. And second, use of the created sent date metadata field for emails, as well as the custodian, sender, and recipient metadata fields to show the fact of communication. CareFirst's characterization of deposition testimony based on the facts in evidence and absent an impermissible negative inference about the content of privileged material is also admissible. The court finds the following uses of the privilege log and or metadata are inadmissible. First, using use of any privilege log entries to demonstrate that particular entries are related based on the created sent date of the entries and or the subject line of emails. And second, invocations of privilege during deposition. Summary, Judge Walker in this case set pretty limited parameters for CareFirst to use J&J's privilege log information as evidence. So what advice do you have for our audience for limiting the ability for your opponent to use your privilege log as evidence?
Well, I think during the meet and confer, you can possibly introduce the fact that maybe you don't use the substance of entries to establish facts beyond the log or for impeachment purposes. And then also perhaps that entries should not be produced without their surrounding context, if that is something that you want. It's something to discuss and document.
Mm-hmm. Yeah, absolutely. So Tom, I'll put you on the other side of this issue. What advice do you have for our audience for pursuing the ability to use your opponent's privilege log as evidence?
Well, I think Judge Walker laid out some really good points about how to do that, but I think it's important to say first that the opinion in this started with citing a Fourth Circuit authority. So first and foremost, check case law and authority in your circuit to see if this has been addressed and if there are some guidelines that have been thrown out there. Just because we've got an opinion from the Eastern District of Virginia. If you're in California, whatever, if you're in another circuit, you have the authority there. Judge Walker talked about it. Mary just touched on it. You can't have a negative inference from the proper invocation of the privilege, but you can't talk about what the privilege communication, as the judge said, quote unquote, must have been about. You can talk about the creation of dates and using the metadata for the, especially the created and sent date, to talk about the meaning of the metadata fields and how that tracks things. But that's it. You can't use it in any way to infer the substance of the documents. The other thing is, I think the judge talked about some problems with family related issues, the family of the documents. Don't disconnect documents from their families because that could be misleading to the jury.
Right. That definitely adds context, because the family connection matters for sure. Absolutely.
Yes. Yeah. So just as the judge said, lay a foundation as to the meaning of the metadata fields, and talk about the facts of the document's creation or download in conjunction with the family IDs. And then I think you can get it. Just steer away from trying to draw any inferences about what is privilege, which is the substance of the discussion.
Yeah, for sure. So, Judge Peck, did you ever have any parties attempting to use their opponent's privilege log as evidence? And do you agree with how Judge Walker ruled in this case?
I never had lawyers who were either that creative or that devious or whatever. No, it never came up in front of me. I agree largely with Judge Walker's decision. And I think, really this in some way takes us back to the good old Zubilake days, using the chronology from the privilege log. So as we all know, but it's been a long time, anticipation of litigation is necessary for there to be work product protection. Anticipation of litigation is also the test for when you need to have a legal hold in place. So, for example, if there is an early work product communication on the Privlog, and that happens to be before, the party involved did their litigation hold, there could be a problem. So that is, a typical example, using work product as a trigger for the duty to preserve, which presumably the other party did not do. So chronological use of the material certainly seems to be fair game. Anything else, if you get substantive, that's invading the privilege, and you either should have challenged the invocation of privilege pre-trial or not, but you can't get that in front of the jury. And in answer to Sheila's question, would it be a subject of jury instructions? Possibly, but it's, perhaps the sort of thing where there would be a motion in limine or other motion to keep the information from ever getting in front of the jury if it was on the impermissible side of things.
Yeah, that makes perfect sense. So, all right, and we'll move on to our next case. In this one, Plaintiff Lim had access to her personal Gmail account on a company-issued laptop during her employment, a practice expressly permitted under Expel's employee handbook as follows. Employees may use company property only for business purposes. You may use company property for incidental personal reasons only if this use doesn't interfere with others' ability to work, place undue burden on Expel, or violate confidentiality. Following her termination, Expel retained the laptop rather than wiping it, citing Lim's retaliation allegations. Years later, during litigation, their consultant control risks discovered that LIM's Gmail data covering more than 15 years had been downloaded and stored on the laptop's hard drive. Although the consultant limited its review to metadata and did not review content, Expel sought the right to review the data in its entirety to determine relevance, leading to LIM's protective order request. California Magistrate Judge Allison Goddard examined whether LIM had established a prima facie invasion of privacy by showing a legally protected privacy interest, an objectively reasonable expectation of privacy, and a serious threatened intrusion. Regarding the first element, LIM's personal email data included financial records, medical information, and home security images, core categories of information recognized as protected by California's constitutional and common law right to privacy. Although the policy stated that data stored on the laptop belonged to Expel, Judge Goddard found this language at best ambiguous as to personal data and held that ambiguity must be construed against Expel as the drafter of the policy. She also stated that doing so would lead to the absurd result suggested by Expel here, that Expel is entitled to peruse more than 15 years of LIM's highly personal and confidential information, including communications with her attorneys, without any restrictions. She also rejected the cases cited by Expel, and as Judge Goddard explained, permitting employees to use company-owned devices does not diminish their expectation of privacy, it increases it. Noting that Expel sought unrestricted review of emails spanning a period nearly 10 times the length of her employment with Expel and beginning more than a decade before her start date, she also found it resembled an impermissible fishing expedition under Rule 26 and rejected Expel's contention that an existing confidentiality designation would suffice. Judge Goddard cataloged the extensive discovery already conducted, including detailed interrogatories, document productions, depositions, and emphasized more than 50 subpoenas on LIM's past and prospective employers and her medical and health providers. These efforts, Judge Goddard found, provided Expel ample opportunity to obtain relevant discovery without unnecessarily subverting LIM's privacy rights. So Judge Goddard ordered that neither Expel nor Control Risk may access or review the personal email data without Judge Goddard's advance authorization upon a showing of good cause, and that within 30 days after the termination of the action, Expel and Control Risks must delete the personal email data and certify in writing that they have done so. So Tom, if Expel had an explicit policy allowing them to review personal data on their company laptop, do you think the ruling would have been different?
Maybe. I mean, I think Judge Goddard expressed an extreme distaste for allowing an employer to look at this extensive amount of personal information, including medical information and attorney-client communications. So it certainly would have given them a leg up in their argument. You know, they opened the door to this whole thing by having a policy that didn't define things deeply enough or explicitly enough. You know, as Judge Goddard noted, the policy allowed the use of company-issued equipment for incidental personal purposes, but then, quote, does not state that Expel has the right to review personal data on the laptop. I suppose they could argue, if they said they did have the right, that they could have. You're going to have a whole second level of argument there, right? I mean, can the client give that away? Do they have, what sort of bargaining power do they have in that policy? Is it an adhesion contract? Blah, 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 blah. That's all. I mean, honestly, if I were an attorney counseling this woman, I would say, if I was having communications with her, exchanging email with her, I think at some point I would say, you're not doing this on a company laptop, are you?
Right.
Why would you store, what was it, over 15 years of personal information on the computer at work? That goes a little beyond what the company allowed for, quote, incidental personal purposes. And maybe they should have argued that a little bit more. But, boy, it's just a bad idea to do that, right?
Right.
So I think a stronger policy may have opened the door. I don't think Judge Goddard was inclined to allow it either, even if it did.
Yeah, yeah, I kind of feel like you're right. And of course, keeping in mind that, I mean, she might have communicated on multiple devices. So she might have been communicating with her attorneys via her, mobile device. Might have forgot the fact that all of her personal emails were being downloaded to the company laptop. So
Yeah.
it doesn't mean she was using the laptop for communication, but it still ultimately wound up there. So
Yep.
definitely
I think
it's a consideration. Yeah.
We see people with two mobile devices to avoid this sort of problem. So they do their company work on one phone and they do their personal stuff on another. Presumably, from this, it seems like she was actually not only using the company computer, but that it was not a separate personal email account. At least that's what I sort of get from this, and that would be the first thing, after the lawyer said, "You're not communicating with me using your company device." The second question might be, and you're doing this on a personal email where the company, wouldn't have the login information for it or whatever. Somewhat curious as to why so much of this was available to the employer. And one other point before I hear what Doug's question is for me. This is California we're dealing with here, where,
right.
Privacy is a human right and all of that, almost like dealing with the EU and the GDPR. I think in New York it would sort of be, privacy, but if you did all this on your company computer with your company email account as opposed to a personal one, we'll cover it with the protective order, confidentiality order, and too bad. But California is different.
Right. Yeah. That definitely had crossed my mind there. And Texas, forget about it. But, Judge Peck, it seems like the control risks consultant found out a lot about the email data just by reviewing the metadata, such as the fact that there were 15 years of email. Isn't that a violation of privacy itself?
Yeah. It's all going to be a question of degree. That it's 15 years worth as opposed to, 15 minutes worth. Sure, but that doesn't tell you what the content is. There's other information in the metadata that could be revealing as to content. And I think this was sort of a balance of, what had occurred, what the court could stop from following up with in the future, but not what, not get the consultant or whatever in trouble for invasion of privacy just from metadata.
Yeah.
Right. Yeah. So Mary, what advice do you have for our audience regarding company policies for personal data on company equipment like laptops?
Well, the first thing for individuals, read them, read the policies, and then certainly don't put confidential data, even if they allow you to, on your employer's computer equipment, storage, or whatever, because if you ever need to say that this is private data, it's going to cost you. Just imagine what this particular back and forth cost for it. And then for the companies, I think it's important that employee handbooks and policies be reviewed by legal and or information governance, or both personnel, so that being nice or trying to create a nice work environment doesn't open up a whole host of risks that are totally unnecessary.
Right. Yeah, absolutely. It's just a bad idea to have that much personal data on the company device, and really a bad idea to have any personal data on a company device. Sheila Greela notes that most corporations and large companies are blocking gmail.com and other personal email access from company-owned laptops. I definitely think some are, for sure, and that's probably a good idea. And then we also have a question, what about any other employees who access their email on the work laptop? Does their information get deleted also? I guess my answer to that would be, well, if they file a case, then they probably would get there. But otherwise, I don't know. If they turn in a laptop, it's going to depend on the circumstances, right? Thoughts from any of y'all?
Well, two thoughts. One, I'm not sure that deleting the 15 years worth of Ms. Lim's email was the appropriate way to go, as opposed to saying, put it on a thumb drive or whatever, give it to her lawyer, and then delete what's on the company server. If that was her only email, which shame on her if so, but if that was it and 15 years worth was now being destroyed, that seems onerous. And I suspect other employees would, if they cared, be going back and deleting it from the company email system as much as possible. But otherwise, it'll be a problem for them at some later point.
Yeah, for sure. Yeah, 15 years worth of email. You wonder how much space she had left for business stuff. So that's a lot. So on to our next case. And in this case, involving claims of unlawful termination of a disabled Navy veteran by Alto, Illinois Magistrate Judge Ronald Hanna addressed 3 disputes. The first one centered on request for production number 9, which Judge Hanna stated stretches the boundaries of even the most liberal interpretation of today's federal discovery regime. And he added that while nearly a paragraph in length, can be summarized as follows: all documents and information related to every Alto employee, past or present, identified in the party's initial disclosures. The request clarifies that it includes the employee's medical records, leave records, rate of pay, and employment applications, and Judge Hanna referred to it as strikingly broad. After concluding that Rule 37's meet and confer requirement has been satisfied, the EEOC clarified that it sought only the personal files of decision makers involved in the employee butcher's termination and excluded medical records, financial information, or information about family members, which Judge Hanna found to be reasonable. So Judge Hanna therefore ordered production of the personnel files of decision makers involved in the termination, noting that a decision maker is the person responsible for the contested decision and directing the parties themselves to determine which individuals actually participated in the decision. The second request sought all documents in Alto's possession that refer or relate to Mark Butcher, the Navy veteran who was terminated. Judge Hanna stated the EEOC's second request is without a doubt proper because Butcher's employment with Alto and Alto's reason for terminating him are at the heart of this case. The documents sought by the request are relevant to the EEOC's claims, also noting that the request was not disproportionate as Alto employed Butcher for less than 4 months. This issue arose after a deposition revealed an email exchange between concerning Butcher's termination that had not been produced. Although Alto later produced the emails, the oversight undermined the EEOC's confidence in Alto's search efforts. So the EEOC sought a court order directing Alto to conduct a prompt and thorough search for all responsive documents, explain its search methodology, and produce all documents in full compliance with Rule 34 and EEOC's requests. In response to that request, Judge Hanna stated, given the obvious relevance of the EEOC's discovery request, the court finds that such an order would be appropriate. Judge Hanna also stated regarding the format of production, in ordering Alto to certify its compliance with the EEOC's discovery request, the court emphasizes that Federal Rule of Civil Procedure 34B2E requires Alto to produce documents as they are kept in the usual course of business. The EEOC reads Rule 34 to implicitly require the production of all metadata associated with electronic documents. Not so. Courts instead adhere to a modest legal presumption in most cases that the producing party need not take special efforts to to preserve or produce metadata. Since the EEOC's original request made no mention of metadata, Alto's only obligation under Rule 34 is to produce responsive documents in their native form as they are kept in the usual course of business, which this just in contained metadata. So, Judge Peck, it seems like defining a decision maker as the person responsible for the contested decision leaves out those who might have been consulted about and had influence on the decision. Is that definition by Judge Hanna too restrictive?
I think it is, who is the decision maker will be very fact dependent. Sometimes it is one person who makes the decision. More often, it's a small group of people who give input to the ultimate decision maker, but it's separating that sort of grouping from anyone who may have provided any information to the decision-making group. So, for example, if Butcher was fired for excess absences, the clerk who went through the calendar and sign-in information and all that to figure out how many absences there was, and then gave that information to somebody else, that's a difference, between someone just providing some core data and somebody making the decision. So it's going to be fact dependent, and the parties should be able to meet and confer and come to an agreement on it.
All right. I guess we'll see.
Emphasis on should be able to.
Right. Well, I guess we'll see if another dispute pops up in in the hopper, and if so, we'll try to cover it. So, Mary, Judge Hanna focused on the fact that the EEOC's original request made no mention of metadata, but stated that Alto was obligated to produce responsive documents in their native form as they're kept in the usual course of business under Rule 34. Isn't that kind of much ado about nothing, and doesn't that give the EEOC the metadata they need anyway? Mary, you may be muted again.
Well, yes, indeed. Yes, indeed. Sorry about that. Trying to keep the background noise to a minimum here. But yes, the emails in particular, when you're producing them natively, if you can produce a PST or a MSG, you actually have the structure to derive metadata, and you get more than regular metadata. You get header information and things of that nature. But asking for native files doesn't always get you like the file as it was pristine. You sometimes get the file with the metadata extracted into a load file. The file name itself might transmorgify into a native file Bates number. So it's not really clear what they would get, Doug.
Mm-hmm. No, that's true. And I mean, as you've alluded to it in your answer, Tom, as you know, ESI is often produced in a near native form because, for example, Outlook emails might be produced as MSG files, even though they've been originally stored in an OST or a PST file. So with that in mind, how would you structure your request to ensure you get the metadata you need?
Well, the easiest way, of course, is to ask for it specifically. As Mary just mentioned, and you alluded to in the introduction, saying native files doesn't exclude metadata. It may exclude certain types of metadata. Even in your example, OST and PST files have file level metadata as well as mailbox level metadata. So best practice would be ask for, in the request specifically what you're looking for. And remember that, the Sedona principles say all relevant metadata should be preserved and produced. But I wouldn't just ask for relevant metadata. I'd specify what I want. Again, to a point I made in an earlier case, this is a subject that's ripe for discussion at the meet and confer. Why not hash these things out early and get it taken care of then? Or at least get that issue on the table. And if there's a dispute, get it in front of the judge.
Yeah, absolutely. And I think the type of metadata could vary widely depending on the type of data that's important. So, for example, if you've got, let's say pictures off an iPhone, you might have some metadata unique to that could be important,
Right.
unique to the pictures, like including the geolocation of where the picture was taken or something like that. So,
Yep.
yeah, absolutely. Request the metadata you need. And it could vary depending on different types of evidence you're dealing with, for sure.
Yep.
Yeah. All right. So our last case, well, earlier we discussed in-camera review of 20 documents. This one had a request of a few more documents. Here, the defendant sought to compel production of documents responsive to its first set of document requests served in December 2024, and a subpoena served on third-party risk strategies in April 2025. When discovery closed on October 10, 2025, defendant had already received extensive document productions and privilege logs. Although Mississippi Magistrate Judge Jane Verdon later granted a limited 70-day extension of discovery at plaintiff's request, that extension was narrowly tailored and explicitly restricted to discovery relevant to establishing or disproving defendant's 3 new affirmative defenses. Despite that opportunity, defendant did not propound any new discovery directed to those defenses. Instead, it filed the instant motion to compel on November 26, 2025, seeking production of all documents previously withheld as privileged in response to its original discovery request and subpoena, requests that predated and did not concern the new defenses. As you can imagine, that request didn't go over well. Stating the instant motion is due to be denied for a host of reasons, Judge Verdon noted, as of October 10, 2025, discovery in this case closed pursuant to the case management order. The discovery that had been propounded and responded to by that date included, of course, the defendant's first set of document requests and the subpoena issued to risk strategies. Defendant's suggestion that motion practice related to discovery that was not even propounded for that purposes of the 3 new affirmative defenses might properly be compelled under my order of October 21, 2025 is without any merit. Judge Verdon also added, moreover, the suggestion that the instant motion was under the circumstances filed in sufficient time so as to allow the court an opportunity before December 30, 2025 to consider, issue an opinion on, and have the parties effectuate the same is not even colorable. Among other obvious reasons such a suggestion is wholly unrealistic are these, and she listed several. I'll note a couple of them here. Number 6 was the documents identified as privileged and which the defendant seeks to have the court rule on regarding privilege are roughly 150 in number, totaling in excess of 50,000 pages. To facilitate resolution of the motion in a timely fashion by December 30, 2025, defendant suggests the production to the undersigned of all 50,000 plus pages in camera for review and decision on the claimed privilege. And 7 was the motion was not ripe until December 18, 2025. In denying the motion, Judge Verdon stated, in sum, I find that defendant's out-of-time Hail Mary effort to have the court compel the wholesale production of over 50,000 pages of documents that were claimed as privileged long ago is futile. So, Mary, do you think this is a case of lazy lawyering by the defendant to wait so late to file their instant motion to compel on all documents previously withheld as privileged? Or do you think there's a potential strategic reason that they would have done so?
Yeah, well, the lazy lawyering, I think if you look at how many pages, there's a litany of lots of documents to, at the close of discovery. But I think what the judge said was that discovery did not pertain to the 3 new affirmative defenses, and any suggestion that it did would fly in the face of defendants' repeated representations to the contrary made in support of its motion for a late leave to amend to assert those defenses. So I think they were on the knife blade there. I don't think it was necessarily lazy lawyering.
Yeah, it was definitely not taken well by the court, for sure. So, Tom, if you were in charge of the defendant, what would you have done differently to have a better chance of succeeding to get at least some of the privileged documents considered for reclassification?
Well, I'm mindful. I don't wait until the last minute, I guess is what it comes down to. I mean, that last line by the judge, I find the defendant's out of time Hail Mary effort to have the court compel this. You know, when the court is referring to your motion as a Hail Mary effort, you know you're up against it. So, you know, don't let things get that far. Just like in a football game, you don't want to get down to the point where you're just throwing one deep into the end zone and hoping somebody catches it and something good happens. That's not a good strategy. But the other thing also is cut it down. I mean, if you're going to do that, don't. In the list there, the motion was 535 pages in length, with another 28 pages on the memorandum. I mean, and you want to have the court do that over the weekend? That's I'm sure. I won't speak for Judge Peck, but I can't imagine any judge is going to agree to that. Right.
Right. Well, yeah. Much less the 50,000 pages they wanted to review in camera.
Exactly. Then and then on top of that, you throw the 50,000 in front of the judge and say, "Hey, let's get that done in camera." Like, it's just not going to happen. So let's be realistic. Yeah.
Over the holidays, no big deal. You know, probably a more selective, you know, kind of questioning of privilege could be in order here as well.
Pare it down to something that's reasonable that the court might look at and say, "Okay, I can handle that," and we can do that in the time that's left to us here. Yeah,
for sure. So, Judge Peck, the untimely motion with the potential expectation for Judge Verdon to actually review 50,000 documents in camera seems obviously over the top. Could Judge Verdon have gone a step beyond simply denying the motion and issued some sort of sanctions against the defendant or their counsel?
Well, you know, I'm not sure what rule we would invoke other than my rule 1.1, don't piss off the court, about, you know, filing a motion that would require too much judicial review, et cetera, et cetera. I'm not sure, you know, what 26 or 37 rule this would fall under, but it's also probably unnecessary. I don't know if we could tell, or I certainly don't remember whether this was Traveler's inside counsel or outside counsel, but the fact that this discovery was denied may well be enough of a sanction. The client probably is not going to be happy about that, and unlikely perhaps to hire that outside counsel again. You know, unless there was some strategic reasoning behind all of this, which doesn't seem to have been apparent to any of us. You know, nothing like leaving something till the last minute, getting a judge's decision that, you know, attacks you for doing that. You know, one of the quotes here, I love this, and it's, you know, using the word respectfully, which usually lawyers use on judges. With all due respect, Judge, which means, Judge, you stupid idiot. But, you know, here's what the judge said here about counsel. Respectfully, I find the suggestion that this allowed for meaningful time for a full briefing and judicial resolution of the issues is ridiculous. And I'm emphasizing ridiculous and closing the quote there. You know, I think Travelers certainly got the idea that their lawyers did not do a very good job here.
Yeah. No, to say the least. So Sheila Grilla pointing up that follow-up and calendaring are mandatory and hire great paraprofessionals. Couldn't agree more. You know, having a sense of the calendar is always important and not always followed, as maybe this case illustrates.
Or the fact that we're doing this on a federal holiday illustrates.
Or the fact that don't get certain people started on that. So yes, indeed. Well, you know, calendaring is good for all of us. What can we say? Great point. So now for the contacts page, and we have a date for our next webinar, which is not on a holiday unless you're Irish.
Because of course, that's a holiday. What are you talking about?
It's a date for O'Connor. Tuesday, March 17th.
Yeah.
Yeah, I don't know if we have luck of the Irish, but I have luck of Judge Peck, who's already given me a couple of cases for that one. So with that, I'll say thanks to Mary, Tom Peck and Judge Peck as always, and I'll turn it back over to you, Mary.
Thanks, Doug. And we thank you and Tom O, the Honorable Judge Peck, for this insightful presentation. And thank you to the EDRM community for your kind attention and your great questions. If you enjoyed today's presentation, show our faculty some love, explore the resources at the bottom of your console, share an emoji or a reaction, and we look forward to seeing you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Thanks, everyone, and happy March.